Welcome back to Guns and Gadgets, the premier source for Second Amendment news. We got a big win today in the Second Amendment realm, and it is going directly in the face of the anti-gunners following the New York State Rifle and Pistol Association versus Bruen. And it's a big win because this is a hotly contested subject across the country and in the different federal circuits. Here's page 1 of the lawsuit, and this is the United States District Court in the District of Minnesota, and the case is Kristen Worth, Austin Dye, Axel Anderson, the Minnesota Gun Owners Caucus, Second Amendment Foundation, and Firearms Policy Coalition versus all the anti-gun people in the state of Minnesota. Now, I want to read you the beginning here. We're going to talk about what the judge said and why this judge in particular might have written the best decision since Bruen. The judge said, "The state of Minnesota requires a person to obtain a permit to lawfully carry a handgun in public, but does not issue permits to anyone under the age of 21. The plaintiffs, who are 18 to 20-year-old individuals and firearms advocacy organizations with members in that age range, argue that the minimum age requirement in Minnesota's permit to carry law violates their Second Amendment rights to keep and bear arms. The parties have filed cross motions for summary judgment. The Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen compels the conclusion that Minnesota's permitting age restriction is unconstitutional, and plaintiffs are entitled to judgment as a matter of law." Now, I mentioned that this judge might have written the best Second Amendment ruling since the Bruen decision without, I don't know, maybe she did realize it, but probably without intending to do it. Why? Because she is a Joe Biden appointed judge. And I'm going to read you one of the great things she said here, which is phenomenal. She did awesome, really, she did. She went through just like the Bruen decision says. She went to the text of the Second Amendment. Then she looked at historical and traditional regulations to the Second Amendment that would have, I guess, kept 18 to 20-year-olds from carrying firearms. And check this out. The commissioner suggests several reasons why the court should find that such militia laws are not evidence that 18 to 20-year-olds had Second Amendment rights. For example, the commissioner suggests that militia laws compelling some men under the age 21 to keep and bear arms did not automatically create a right because imposition of a duty does not necessarily confer individual rights. The fact that early America governments compelled some infants to keep and bear arms did not establish a right that an infant could claim against the government. While true, the significance of the Militia Act of 1792, or indeed any of the founding era militia laws referenced in the cases cited above, is not that they created a right to keep and bear arms at all. Indeed, Heller described the Second Amendment as having codified a pre-existing right. Similarly, Heller explained that the well-regulated militia mentioned in the amendment's text was a reference to an entity already in existence. The militia law's significance is that they provide some indication that the existing right to keep and bear arms likely included those who were included in the already existing militia. And in the militia laws, the 1792 Militia Act, 18 to 20-year-olds were compelled to show up at muster and bring their firearms to serve in the militia. So this judge went all the way back to the militia laws, which was phenomenal. The Militia Act is plain if you read it. The Second Amendment is plain if you read it. And Bruen says that you must go to the plain text of the Second Amendment, and we all know what that says. And then if the action of the citizen is covered by the Second Amendment, then it's on the government to prove that somewhere in the history and tradition of firearm regulation at around the time of the founding of the Second Amendment, that these gun control laws existed, and they're finding over and over again that they didn't, because we know they didn't, and they can't back up their claims. Guys, I've been saying it for months now that the pillars of gun control are cracking, they're crumbling, and the left, as you can tell right now, if you look around, the left is going batty because they're realizing they're not going to be able to strip our right away, and that's phenomenal. And this is a Joe Biden appointed judge, and she did a hell of a job. Now let's go to the end of this ruling and read her order. For the foregoing reasons, it is hereby ordered that 1. Plaintiff's motion for summary judgment is granted in part. 2. Judgment is granted to plaintiffs on the issue of whether Minnesota statute section 624.714 subdivision 2B2 violates the right of the individual plaintiffs and the otherwise qualified 18 to 20-year-old members of Minnesota Gun Owners Caucus, Second Amendment Foundation, and Firearms Policy Coalition to keep and bear arms is guaranteed by the Second and 14th Amendments to the United States Constitution. A, the court declares that Minnesota statute blah-blah-blah, blah-blah-blah, requirement that a person must be at least 21 years of age to receive a permit to publicly carry a handgun in Minnesota violates the rights of individuals 18 to 20 years old to keep and bear arms protected by the Second and 14th Amendments. And B, defendants are enjoined from enforcing the 21-year minimum age requirement in Minnesota, blah, 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 against the individual plaintiffs and otherwise qualified 18 to 20-year-olds. 3, Commissioner Harrington's motion for summary judgment is denied. And 4, Sheriffs Lorge, Walberson, and Starry's motion for summary judgment is denied. Let judgment be entered accordingly. Today's date, and this is Judge Catherine Menendez, U.S. District Court Judge, and like I said, a Biden appointee. And she did a hell of a job. And I don't even know if she intended it to be this great, but this is going to stand, and it's going to be cited in other courts in this 18 to 20-year-old fiasco across the country. Guys and gals, let me know what you think about this down below. If you are interested in the Second Amendment and us returning to our actual Second Amendment, then subscribe to Guns and Gadgets here. I will constantly give you the information every single day, good, bad, ugly, or indifferent, no matter what time it happens. And with you, we become stronger, and thank you for your consideration. Till we see each other again, be safe, stay vigilant, and carry a gun to keep you, your friends, your family, your community safe. I'll see you all in the next one. Take care.